We've all been watching Washington, waiting for some grand federal pronouncement to drop. But I've been around long enough to tell you that when the swamp gets quiet, the real action moves to the state houses. And let me tell you, the chatter about 2026 being a quiet year for gun owners, that is snake oil, pure and simple. Flooded, I've got the details right here from folks tracking the legal landscape minute by minute, and what's coming down the pike for owners of AR pattern rifles and AK variants in key states is a total headache, and potentially a jail sentence if you aren't paying attention. We aren't talking about big, flashy federal bans. We're talking about insidious, grinding state-level restrictions, new registration hoops, mandatory storage rules that could land you in hot water over a technicality, and buying restrictions that choke off your ability to replace worn-out parts or gift a firearm to kin. This isn't theoretical. This is happening in your backyard. We're going to break down exactly where the axe is set to fall, why these specific dates matter, and how they are trying to sneak these restrictions past good, law-abiding Americans. Now, let's get straight into the weeds, because this source material lays out a patchwork quilt of future problems across the map. The initial report suggests that most shooters are too focused on DC drama, and that's exactly what these state legislators are counting on. They know the national spotlight shifts, so they sneak in their own language, year after year. Finally, itself is often designed to be vague enough to catch anything they want. Listen to this definition breakdown. New York uses a one-feature trigger, meaning if your rifle has a detachable magazine and one of the so-called military-style bits, a pistol grip, a folding stock, a flash hider, you're already in their crosshairs under the SAFE Act. Then you look over at New Jersey, which uses the dreaded substantially identical clause. That's a legal lawyer's dream for making your perfectly fine rifle illegal on Monday because they decided it looked too much like something on their banned roster from Friday. They're claiming they are targeting assault weapons, but common sense tells us they are targeting features that have been standard on hunting and defensive rifles since well before the turn of the century. Let's talk hard deadlines. Rhode Island is coming in hot on July 1st, 2026, with a full stop sign for making, buying, selling, or transferring prohibited firearms. And what defines prohibited? Semi-automatic, detachable magazine, plus one evil feature. If you already own it legally, great, you get grandfathered. But here's the catch they don't shout from the rooftops. Your ability to resell it within the state practically vanishes. If you planned on maybe giving that rifle to your nephew down the road, that transfer now involves an FFL or shipping it out of state. And if you mess up, 10 years in the slammer and a $10,000 fine. That's not a slap on the wrist. That's a life-changing event over a rifle you bought legally years ago. Then you pivot west to Colorado, and their strategy reminds me of when the IRS starts auditing small businesses. They don't ban the business, they just make it too painful to operate. Starting August 1st, 2026, if you want to add another semi-auto with a detachable magazine to your safe, you need a state-issued Firearm Safety Eligibility Card. You have to sit through a state-approved class, pass a background check, and then renew this plastic card every 5 years. Extra cash, extra time, extra paperwork. They know that hurdle will make casual buyers bail, slowing the market and keeping new folks off the roster. They crank down the spigot without ever uttering the word ban. And don't even get me started on California and the handgun situation. They are using AB 1127 to crack down on so-called convertible pistols, handguns that could accept a drop-in switch to go full auto. Now listen, any good American knows installing a speed trigger or any full auto device is already a federal felony, a serious crime. But California isn't satisfied with enforcing federal law. They are banning the sale of the pistol platform itself if it can be modified. They grandfather current owners, sure, but if that pistol breaks after July 2026, you can't replace it. They are shrinking the supply chain for things that were perfectly legal yesterday. This slow squeeze, where they chip away at accessories, then components, then entire platforms, is the oldest trick in the legislative book. And it's working because folks tune out the details. What is going on here? making us fill out more paperwork for basic self-defense tools than for a mortgage application. Prerequisite loves complexity, because complexity breeds non-compliance, and non-compliance breeds criminalization. That brings us to New York and the long shadow of their already robust SAFE Act. As the report points out, the danger in New York in 2026 isn't a new ban, it's the audit trail. They are moving from a register if you want system back during the initial amnesty period to a prove you registered or face felony charges system. Back in the day, if you owned an AR or AK that hit that one feature threshold, you mailed in a card. You got a sticker, or maybe you got nothing back, but you thought you were squared away. The state assumes you're honest. But what happens when their computers, which let's be honest, move incredibly slowly, flag a serial number they think should be on file, and you can't produce the renewal or update? The system doesn't see a clerical error, it sees an unregistered assault weapon. That's a potential felony. That is how they clean up the roster, by turning honest mistakes into hard time. You cannot plead ignorance when the state mandates you track your own compliance. Then we look at New Jersey and Massachusetts, where the theme is constant reclassification. In New Jersey, every time they update their banned roster, rifles that were clean suddenly land on the no-fly list. If your rifle has the same features as the named rifles, it's in. The key is watching for those roster updates. If you're running an AR variant in Jersey, you better know exactly how the state officially tags it, because the difference between legal possession and 3 to 5 years inside is one administrative footnote they drop on a Tuesday afternoon. In Massachusetts, they are swinging the copy or duplicate hammer hard. They are saying even if a manufacturer marketed a rifle as compliant, featureless, neutered, if the Attorney General decides it too closely mirrors a banned model, it's contraband. And they aren't backing down on enforcement either. First offense, mandatory jail time. Second offense, 5 years. This isn't about safety. This is about attrition. They want owners to get tired, confused, and just give up their rights piece by piece until the only thing left in the safe is a single-shot break-action deer rifle. This system is designed to wear down the common man who has to work for a living and can't spend all day reading complicated legal bulletins from 3 different state agencies. And we can't forget the secondary effects in states like Connecticut, Maryland, and Washington. In Connecticut, come April 1st, 2026, if you registered that rifle years ago, they now demand it be kept in a locked container or secured with a lock on the gun itself. If the police come to your door for a domestic disturbance call, or maybe just a false alarm, and they see that legally registered rifle sitting in a non-compliant safe or secured only by its internal mechanism, they can stack criminal charges on top of whatever else brought them there. You lose the gun, you lose your rights, all because the cabinet latch wasn't heavy-duty enough for their liking. This is the creeping regulation that slowly strangles freedom. Kang, so what is the synthesis here? What is the overarching pattern that these independent actions reveal? It's crystal clear. The strategy isn't a single, sweeping federal ban that SCOTUS could easily strike down using established Second Amendment precedent. No, sir. The strategy is fragmentation and attrition. They are using the decentralized nature of our federal system against us. If a federal ban fails, they push 20 state-level restrictions. Each state implements a slightly different poison pill. Rhode Island bans transfers, Colorado mandates training cards, New York mandates paperwork updates, and Connecticut mandates specific locking mechanisms. The cumulative effect? An owner living near state lines, say someone in the DC suburbs who owns property in Virginia, now has 3 different sets of storage laws, 2 different definitions of an assault weapon, and a completely separate mandatory waiting period or eligibility card scheme to navigate. It's designed to be impossible to follow perfectly. President leads to the crucial takeaway. They are weaponizing complexity and bureaucracy against the Second Amendment. They know the Second Amendment isn't going anywhere federally, not while the Supreme Court is structured the way it is right now, but they don't need to win the constitutional argument federally if they can make possession of protected arms functionally impossible through administrative law at the state level. They make compliance so burdensome, so expensive, and so fraught with potential felony traps that good people self-censor, sell off their property, or simply stop buying new firearms. The report advises taking inventory and locking things up, and that's sound advice for surviving the immediate future. But we, the people who value our constitutional rights, need to stop looking only at the federal stage. We need to organize and hold our state representatives accountable. When a state legislature votes to mandate a $200 safety card renewal every 5 years for a rifle that does nothing different between 1 year and the next, they aren't promoting safety. They are creating a revenue stream and a compliance trap. That's what these layered restrictions do. They build walls around fundamental rights. If you're holding an AR or AK, your homework for the next 18 months is to know your state statute better than your local sheriff does. Because when 2026 hits, the computer doesn't care about your good intentions. It only cares if you followed the letter of the new, confusing, state-mandated law. That is the hidden agenda. Weaponize the fine print. Whether it's through mandatory training cards in Colorado, locked storage mandates in Connecticut, or the constant reclassification games in New Jersey, the message from state capitals is loud and clear. They are using 2026 as a benchmark to tighten the screws incrementally. Staying compliant is dull, but it keeps you in the fight against the slow, steady erosion of our freedoms. So, here's the question for you tonight. If you live in one of these affected states, Rhode Island, Colorado, New York, take your pick, what is the single most confusing or burdensome requirement you are facing under the new regulations coming down the pipe? Drop a comment below if this hits home,